Yes, ma'am.
Chairman.
Senator
Chairman.
Leahy, I just wanted to respond to.
Yeah, we will, but let's, you've spoken.
I know.
System breaks. So you have 5 minutes.
Thank you. I want to just finish with Ms. Clark, and I'll restate the question. If we have Ms. Clark, I hope we do. Are you there?
Yes, I am, Senator.
Wonderful. Ms. Clark, I'll restate the question maybe more succinctly and clearly. My impression about originalism is that it is often used as a smokescreen by activist judges who want to legislate from the bench and substitute their own judgments for the legislatures. My concern, one of them about Judge Barrett, is that her opinion in Cantor indicates an approach, a very activist one, to the Second Amendment that would very possibly strike down common sense gun violence measures such as background checks, emergency risk protection orders, safe storage laws like Ethan's Law in Connecticut, and other measures that are designed to stem and stop gun violence. I'm particularly concerned because of Janet Rice, who is still grieving her son, Shane Oliver, Natalie Barden, who is still mourning for her brother, who was killed in Newtown, and the Songs, Kristen and Michael, who still have a hole in their heart for their son, Ethan. And they championed Ethan's Law courageously in Connecticut. We are a safer state because of the victims and survivors of gun violence, whether Newtown or downtown Hartford, as with Janet Rice, and all across the state, often in communities of color, but literally every community, because every neighborhood, every family, every community is vulnerable to the scourge and epidemic of gun violence. It's a public health menace. Let me ask you about that judicial philosophy, originalism as applied to the Second Amendment. Do you share my concern that it could lead to striking down those laws that state legislatures and hopefully Congress one day will enact to make America safer?
Thank you, Senator Blumenthal. Very briefly, in our analysis of Judge Barrett's record, her Second Amendment jurisprudence reflects an originalist approach, and we believe that her orientation is one such that it would be more likely that it would seek to expand an individual's right to obtain and use guns, and that she would be inclined to uphold that she would likely resist restrictions on the purchase and use of guns. We looked at her decision in Cantor versus Barr very closely. We note that the opinion that she wrote, which was authored along with 2 other judges, is one in which some observers has found to be in conflict with that of every other appellate court that has addressed the issue that was at stake in Cantor. So I am deeply concerned, Senator, that she would put her thumb on the scale of providing more access, easy access to guns in our country.
Thank you very much, Ms. Clark. I'd like to turn to Ms. Good. You describe in your testimony being a survivor of sexual abuse, and you state that you are the person you are today at 16 years old because you, quote, had access to an abortion, end quote. You also may have heard my asking Judge Barrett if she thought, as her legal position, Roe v. Wade was correctly decided, including in cases where pregnancy was the result of sexual abuse. And I brought to her the story of Samantha, who was a rape victim and survivor, became pregnant and had an abortion. How did you feel knowing that Judge Barrett simply wouldn't answer that question about whether Roe v. Wade and Griswold v. Connecticut were correctly decided?
Well, Senator, thank you for the question. And, you know, as a survivor, it's deeply, deeply disturbing. And, you know, it just makes me think, you know, no one cared about consent when I was being sexually abused. And all young people, teens, deserve the right to consent, autonomy, and dignity. And I'm here to stand against this nomination. Thank you.
Thank you very much. Thanks, Mr. Chairman.
Thank you. Senator Hirano.
Mr. Chairman. Mr. Chairman, I have a letter from the National Education Association, which represents 3 million educators serving 50 million students. They are urging the Senate to focus on a COVID-19 relief bill and not, to quote the letter, rush to confirm President Trump's nominee, Amy Coney Barrett, before Election Day, when that is not what the American people want. I ask unanimous consent to enter this letter into the record, Mr. Chairman.
Without objection.
Thank you. I have 2 questions for Ms. Clark, so if you can sign on. Ms. Clark, the Supreme Court's Shelby County decision gutted the pre-clearance provision of the Voting Rights Act, which required jurisdictions with a history of voting discrimination to get approval for changes to their voting laws. After Shelby County, over a dozen states passed restrictive voting laws. During the hearing, I asked Judge Barrett whether voter suppression or voter discrimination currently exists. She refused to answer and pointed out that the Supreme Court did not address Section 2 of the Voting Rights Act in Shelby County, but the Supreme Court has recently decided to take up this issue. Ms. Clark, unlike the pre-clearance provision, Section 2 puts the burden on those who are challenging the voting law to show that the law would result in, quote, a denial or abridgment of the right of any citizen to vote. This kind of burden shifting makes it hard to prevail. Wouldn't you agree? Ms. Clark?
Yes, Senator, I completely agree. Section 2 is not a substitute for the important protections that had long been afforded by the Section 5 preclearance provision.
I think everyone should understand what burden shifting really will result in, that there has to be basically a case-by-case bringing of these lawsuits to challenge whether or not the law passed by a state actually suppresses the vote. So that's a pretty tough burden, whereas the pre-clearance provision basically required the jurisdictions who had to comply with that provision to show that their provision did not suppress votes. Isn't that correct?
That's correct, Senator. And in addition, Section 2 litigation has proven historically to be more costly, more time-intensive, and more burdensome.
Yes, and I think that the Supreme Court, in making that 5-4 decision, should have predicted that that was exactly what was going to happen, and they certainly should have predicted that a lot of states would begin to pass all kinds of laws that would have the effect, at least, of suppressing votes, especially of minorities and blacks. Another question for you. I know you reviewed Judge Barrett's record, including her cases on the 7th Circuit. I did too. And I found two of her cases relating to discrimination in the workplace particularly concerning. The first was EEOC v. AutoZone, where Judge Barrett voted to not rehear en banc a panel decision that in essence approved a separate but equal arrangement. The other was Kleber v. Car Fusion Corporation, where Judge Barrett joined an opinion that effectively approved of age discrimination against job applicants. Can you speak in a little more depth why the Lawyers Committee was concerned about Judge Barrett's record on workers and civil rights?
Thank you, Senator. In the area of workers' rights that we examine, Judge Barrett has demonstrated an inclination to side with corporations and with employers over employees. We are deeply concerned about the EEOC versus AutoZone case where Judge Barrett essentially, along with 4 other judges, refused the federal government's request for a full panel review of a case involving an employer, here AutoZone, which chose to intentionally segregate employees on the basis of race. They assigned Black and Latino employees to AutoZone locations based on race, and they did so explicitly. And the lower 3-judge panel found that this wasn't racial segregation because people were still paid the same and received the same benefits. But the outcome here is deeply disturbing. We do not need a return to an era in which we tolerate intentional racial segregation in any context of society. We're also deeply concerned about Smith versus Illinois Department of Transportation, where Judge Barrett authored a decision holding that a Black traffic patrol driver failed to make a case that he was fired in retaliation for making complaints of racial bias. In this case, the worker was subject to racial slurs. His co-workers used the N-word on multiple occasions, and while the judge recognized that this was a racial epithet, she did not find that there was a sufficient basis to find that he was subject to a hostile work environment. When you look at the sum total of Judge Barrett's record in the Title VII context, it raises grave concerns about her willingness to protect victims of discrimination in the workplace, and seems to make clear her orientation to protect the rights of corporations and businesses.
If I may, Mr. Chairman, so in the case that was an overt race-based kind of decisions, shouldn't that have been a per se violation? I agree, Senator, but we looked at her record and it reflects a pattern. And I think that the pattern that we see across both of these cases indicates a judge who would not be inclined to enforce Title VII of the Civil Rights Act, one of our nation's most important federal civil rights laws, when it comes to protecting workers in the workplace. I have every reason to believe that she is somebody who would side with corporations and businesses. And already we have a Supreme Court, their studies have shown that already is protecting corporate interests over individual rights. Thank you.
Senator Booker.
Thank you very much. I want to thank my more senior senator and friend, Chris Coons, for yielding to me. It's generous of him, and thank you. I want to thank all the witnesses, first and foremost, extraordinary.
I think it's more that I ignored than anything else. I didn't see him over there.
I appreciate that. I want to thank all the panelists. It's really been extraordinary to hear from all of you, frankly, and Crystal Goods really moved me with her testimony, as did Stacey Staggs. I'm thankful. To Ms. Wolk, I just want to thank you for coming in and being around all these people and their hot air amidst a pandemic. It means a lot to me. Mr. Prakash, I would thank you as well, but I'm still mad that you brought up my classmate Noah Feldman in a Supreme Court hearing, as I am mad at the Honorable Griffith for I thought I could get through a Supreme Court hearing without hearing about my con law professor, Akil Amar, but yet I did not make it this close. I want to focus my questioning on Ms. Clark, if I can, and want to thank you for your really important testimony. So I talked a lot about a lot of concerns around race. We're obviously in the middle of one of our larger racial reckonings in our country's history. I started a lot of my questioning yesterday with about criminal law. And I'm wondering maybe if you could just start grounding a lot of my concerns in actual writings of hers. And perhaps you can talk about Miranda first, her writings on Miranda.
Thank you, Senator Booker. We are at an interesting moment. This nomination arises at a moment where people are protesting racial injustice and unconstitutional policing practices. And in our examination of her record, we looked very closely at one of her articles where she talks at length about Miranda, the Miranda doctrine, the doctrine that requires that officers read you your rights when you're accused of a crime. And in her writing, she's described the Miranda doctrine as an example, quote, the court's choice to over-enforce a constitutional norm that she says goes beyond constitutional meaning. And she suggests that Miranda warnings throughout time have inevitably led to the exclusion of evidence, even when some confessions were freely given. I'm gravely concerned that a Justice Barrett on the Supreme Court would mean a court that would be more inclined to chip away at the constitutional rights of those who are accused of crimes. And we know that our criminal justice system is disproportionately composed of Black people and people of color. And so this is an area of grave concern.
And the history of African Americans in the criminal justice system being wrongfully convicted is pretty staggering, even up to recent months.
That's correct, Senator. We also know that racism infects virtually every stage of our criminal justice system, from who gets stopped on the street to lengths of sentences to who gets the death penalty. And those are the kinds of cases that routinely come before the court. And so in many respects, this is a life and death issue for Black people and people of color who are subjected to punishment at the highest levels in our criminal justice system. And
there's a lot written about this. There's a lot of studies about how African Americans in particular, but people period, have been churned into a system regardless of innocence or guilt. In fact, I mentioned, you heard me riff off a whole bunch of well-read books, but even now by the general public. You're familiar with one, Why Innocent People Plead Guilty, correct?
Yes.
Yes, and it's this book that documents how we have a criminal justice system. It's no longer even trials. We've gotten to a point now that 98% of our criminal convictions are done by plea bargain. Are you familiar with example after example, I would imagine, as I am, dozens and dozens in my time as mayor, of young people caught up in the criminal justice system that plead out just simply to get out of jail, correct?
Yes, and we also are deeply familiar with the resurgence of debtors' prisons, which entangle poor people who are disproportionately people of color in the criminal justice system merely because of their poverty.
Right, and can I want to end with a question, I'll get a little bit of a grace period here. The first time I visited Rikers Island, visiting youth lockup, Ms. Clark, I was stunned, and I'm embarrassed to say I was already mayor of the city of Newark, that I was there thinking I was visiting people who have been convicted of crimes, met with a whole bunch of teenage kids, and I asked them how long they'd been in for, and they were like 6 months, 8 months, a year. Still remember them, 18 months was one of them. And I said, well, what have you been convicted of? And they all look at me and saying, we have not been convicted. And these were people in for relatively minor accusations where they were stuck within the criminal justice system. That led Brian Stevenson, the quote I used yesterday of his, that we have a system that treats you better if you're rich and guilty than if you're poor and innocent. This is not something that's an occasional miscarriage of justice. These go on in thousands of cases in every city in America where you see young people being churned into the system, being put into solitary confinement, which is still legal in most states, which psychological professionals call torture. Then they're let out of prison now, having those deeply psychological effects, still often not convicted of anything. And this is rife within the system. And to say that some of these basic protections like Miranda are the over-securing of rights, to me is an astonishing lack of knowledge about what actually goes on in our criminal justice system every single day. And to sit on the highest court in the land and not know about what anybody who works in the criminal justice world. I've seen some federal judges break down in tears about having to follow mandatory minimums. I've seen prosecutors come to me and say there's got to be a different way. But to see that we are, the concern I had about not being familiar with some of these basic studies coming from, and you know this, I won't name the people on the right, the organization, some of them have been vilified at this very hearing, that I found common cause with to try to correct some of these tragedies. Could you just finish just saying, is anything I'm saying overstating the fact?
No, Senator. And the most notorious example of the crisis that you just described is Khalif Browder, who was held for almost 3 years at Rikers Island because he couldn't post bail because he was poor. He was accused of stealing a backpack. He was never actually brought forward for trial, and he ultimately took his life. He committed suicide because of the trauma that he experienced at Rikers. He was held in solitary confinement for much of his time. And so Justice Barrett's record on race and criminal justice matters, and her writings on Miranda provide a powerful roadmap into how she would likely handle criminal justice cases that come before the Supreme Court. This is in large part another reason why we oppose her nomination.
And so I just would say, in closing to the chairman, we sit in a country where you're comfortably sitting here right now while children are being tortured in solitary confinement right now, disproportionately black, disproportionately poor. We have a system where blacks are, as I quoted the data, disproportionately stopped by police, even though they find traffic stops that white people who actually are found with drugs more than black people when they're stopped. You could go through every part of the system, from station house adjustments all the way through to sentencing, treatment in prison, perceptions of threat that are often deeply affect whether somebody gets probation or parole, and then the collateral consequences if somebody is poor now, that when they get out of prison, their collateral consequences they face are much different than someone who is wealthy who comes out of prison. And so it just so frustrates me that we have a national shame that our criminal justice system is not just, that we do not have equal justice under the law, that we are a nation that still engages in things that other countries call torture to people in our prisons, and that we do not, number one, have a sense of urgency to do something about it. Number two, continue to put people on the highest court in the land who are not even familiar, it seems, with the scholarship around this issue. Thank you.
Just a few brief comments, and we'll finish with Senator Coons. Bail reform, I think there's some legislation to abolish cash bail. I think Senator Rand Paul maybe is on it, and Senator Harris. I've tried to work with Senator Booker. I find you very knowledgeable in trying to seek common ground. You've seen states that basically abolish bail and drop somebody off in the morning, they're back out on the streets in the afternoon committing violent crimes, and you have the situation about some young man 3 years for stealing a backpack. I get it. There's the other side of the story. To the extent that we can create a parole system in the federal system, count me in. See, our federal system doesn't have parole. The First Steps Act is a review of sentences for nonviolent offenders, but Senator Lee, you've been really good on this. I would like to take a shot at trying to see if we can come up with some pilot program for parole, because I went to a facility in South Carolina where a man had been there about 35 years. He was in his 50s, and every guard said he's here for no reason. And the guard said, this guy over here, if he ever gets out, he'll kill the first person he meets. So I'd like to have a system that addresses what you're talking about, but that doesn't lead to a catch and release in terms of the violent offenders.
I just want to say I welcome that. Sure. Every prison I visit, and a lot of conversations about faith. Matthew 25 really drives me. Did you visit me in prison? So I try to visit prisons. Every warden, toughest wardens you name it, I always ask them that question: are there people here that don't belong? And they look at me and they say, absolutely.
Without a doubt.
Absolutely. Yeah.
And they say, would parole help? And they said yes. I'd be the first one to go to the parole hearing. Yeah. Senator Coons.
Thank you, Mr. Chairman, and to my colleague from New Jersey. As you well know, Corey, it was my own father's volunteer work in prison ministry that really shaped my young life. My first visits to our state prison were when I was in middle school, and my dad was going to visit a Bible study group and brought a convicted murderer home on parole weekends to our house, which really shaped my sense of what it means to be willing to take risks for those who the rest of society has given up on. And the First Step Act, which you played a central role in, as was graciously recognized by the chairman previously, was meant to be a first step along a long journey. And we have a lot of important work we can and should be doing in addressing the ways in which our criminal justice system is profoundly unjust, We are months and months past the point where the people of Delaware at least expected action on reform efforts here legislatively to deal with racial inequality. And that should be on our agenda every day. It was the judge for whom I clerked on the Third Circuit who first took me to a federal prison. She made sure that every one of her clerks went to a federal prison, met with federal prisoners, had an understanding of what the consequences were of the decisions that we were contributing to. And I frankly think everyone who serves in this role should have that insight, both into victims' families and the consequences of crime, but also into what incarceration means, what things like cash bail and solitary confinement mean, particularly to young people. I've had a bill on solitary confinement of juveniles for a number of years. We should work on this. But let me get to questioning the panel. Forgive me, you touched a point of passion there, Senator Booker. If I could just briefly, since I know I am the last questioner today, Dr. Bhatti from Lansing, Michigan, if I might. What kind of, two things. Rudy Giuliani, in speaking to an event about COVID, recently said people don't die of this disease anymore. Is that accurate? And what, if any, kind of meaningful relief can Congress provide that would actually help your clinic in Lansing, Michigan, and help those in public health respond to this pandemic?
Thank you, Senator, for the question. I think flatly the answer to your first question is no, it is not accurate. People are still dying every day. In fact, 1,000 Americans each day are dying because of COVID. And there's a lot that Congress could be doing to help my patients. You know, you could be potentially expanding unemployment, you know, giving people cash assistance. My patients are having difficulty paying rent. I have patients who are finding difficulty even getting food to eat every day. I have patients with difficulty affording medications. And so my patients are facing real life challenges, and they can't afford to wait for an election. And they can't afford for Congress to continue with the hyper-partisanship that we're seeing. They need action now, and that's one of the main reasons I came today, was to advocate on behalf of my patients. Specifically, you know, giving people access to health care. Anybody who has a COVID-related illness shouldn't have to worry about going bankrupt because of that illness. And then making sure that we protect those people moving forward so that they don't lose their health insurance at any point in the future because of their pre-existing conditions. So those are just some of the things that I think could be done to help protect my patients and help them get a leg up.
Thank you, Doctor. It's my hope that we will find a path in these last 3 weeks before the election to actually deliver a meaningful bipartisan package. It should be robust, and it should provide resources, particularly for grassroots medical clinics. Ms. Staggs, I appreciated your advocacy around the health care of your children. You've spoken about how the Affordable Care Act is vital to keeping your children healthy and safe. My colleagues have said over and over again they want to repeal and replace the ACA. One of my challenges has been finding the replacement plan. Can you tell me what their replacement plan is for the ACA?
Thank you. Can you hear me?
Yes, I can. Now I can.
A few weeks ago, President Trump was here in Charlotte and signed an executive order that he said would protect pre-existing conditions. First of all, the Affordable Care Act is a whole heck of a lot more than protections against pre-existing condition exclusions. Second of all, the executive order that was signed per White House counsel had no legal effect. It was a great idea, but I have to tell you, like you, I remain all ears and incredibly eager to hear and see and read and consider an effective replacement plan. I know that my own senator, Senator Tillis, is he in the chamber today?
He's no longer here. He was earlier.
Okay. I know that Senator Tillis has put forth what is called a PROTECT Act that uses the term pre-existing conditions, but in effect doesn't meet the standard that we currently have with the Affordable Care Act. So I would just say to that the American people are on pins and needles and feeling very anxious for whatever replacement plan might someday appear, so we can understand what the impact is. I'm sure you can understand then the anxiety that comes with the absence of that. I mean, since 2017, when the little lobbyists first started to come together, we've been facing a future with threats to the Affordable Care Act minus a viable replacement, while our children's lives hang in the balance. It's been incredibly difficult and stressful for years, and that continues and feels more immediate with each day.
Well, thank you, Ms. Staggs. One of the things I try to emphasize in talking to people in Delaware is that the Affordable Care Act doesn't just protect the 20 million Americans who get their health care through ACA exchanges. It doesn't just protect the north of 100, maybe as many as 130 million Americans who have pre-existing conditions, now 7 million more because of this pandemic. It actually protects a majority of Americans. And this is relevant because we were this week considering a successor to Justice Ginsburg. It prohibits discrimination against women on the basis of gender. It doesn't allow insurance companies to treat pregnancy as a pre-existing condition or to charge more just because women are women. So it literally protects a majority of the American people. Let me close with just two questions, if I might, of Ms. Clark from the Lawyers Committee. Ms. Clark, my staff has identified, and I put up a board yesterday, of 120 Supreme Court cases that were decided 5-4 that I now believe are at risk of reconsideration or reversal if Judge Barrett is confirmed. One of these 120 cases is Grutter versus Bollinger. It's a 2003 decision that upheld the promotion of racial diversity in admissions at the University of Michigan. Just this past week, the Trump administration sued Yale University for its efforts to promote racial diversity. A case similar to that, the administration has also recently supported against Harvard. Can you explain the impact this case has had for the nation and the consequences if it were overturned?
Thank you, Senator, for that question. There are a number of critical cases in the Supreme Court pipeline, and some of the most high-stakes cases are cases involving challenges to race-conscious admissions policies at colleges and universities across our country. As you know, the Justice Department just recently and astoundingly sued Yale University. There have been similar suits brought against Harvard University, the University of North Carolina, the University of Texas at Austin. My organization is involved in all three of those cases, and they are on a fast track to Supreme Court, on a fast track to the Supreme Court. The Supreme Court has held that race can be one among a number of factors that our colleges consider in pulling together their college classes. What's at stake here is racial diversity, just the principle of racial diversity. I am deeply concerned that a Justice Barrett on the Supreme Court would upend the precedents that have been firmly established in this area, and that would turn back decades of progress in our nation and result in colleges and universities that are not racially diverse, colleges and universities that lock the door on Black students and Latino students who are deserving of access, roll back the clock on equal opportunity. So I'm glad that you asked this question, Senator Coons, because it really underscores how high stakes this nomination is for our nation.
Ms. Clark, you did some important early work in your career on election protection. President Trump and members of this committee have repeatedly attacked the validity of mail-in voting, even though the president himself, members of his family, our troops overseas, our diplomats, routinely use mail-in voting as a way to cast their ballots securely, and there being no credible evidence of widespread voter fraud. We've actually, in reality, seen efforts by the administration to undermine the proper functioning of the Postal Service. We've seen the governor of Texas blatantly try to make it more difficult for voters to submit their ballots in a timely fashion in this upcoming election. We've seen lines between 5 and I think as many as 10 hours in the state of Georgia for those who are lining up for early voting stations. And the president has openly called for voter intimidation. Can you speak to the impacts of these impediments on voting, how they differ from the impact of any alleged voter fraud, and how this does or doesn't align with a long and tragic history in this country of voter suppression?
Ma'am, you certainly may answer the question just briefly if possible.
Yes, Chairman. Senator Coons, voter suppression is alive and well across our country. We see it each and every day in places like Texas, Georgia, North Carolina, states that were covered by Section 5 of the Voting Rights Act. We know that people are struggling to access the ballot amid the pandemic, and there have been lawsuits to tear down the unconstitutional barriers to the ballot, which is why Judge Barrett's views on voting rights matters, and which is why it has been very disturbing to listen to Judge Barrett this week express an unwillingness to acknowledge that voter intimidation is unlawful, to express an unwillingness to acknowledge that voting discrimination is ongoing and exists. And these cases are in the Supreme Court pipeline and on the court's docket, which is why, again, we oppose Judge Barrett's nomination to the Supreme Court. She will turn the clock back on voting rights in our country.
Thank you very much, Ms. Clark. Thank you, Mr. Chairman. Thank you to all our witnesses.
Thank you. Yes, ma'am.
Mr. Chairman, I just want to thank you. This has been one of the best set of hearings that I've participated in, and I want to thank you for your fairness and the opportunity of going back and forth. It leaves one with a lot of hopes, a lot of questions, and even some ideas, perhaps some good bipartisan legislation we can put together to make this great country even better. So thank you so much for your leadership.
Well, one, that means a lot to me, and I know we have very different views about the judge and whether we should be doing this or not. But having said all that, to my Democratic colleagues, you have challenged the judge, you've challenged us, and I accept those challenges as being sincere and not personal. I don't think anybody crossed the line with the judge in terms of trying to demean her as a person. To the people on my side, thank you very much for being involved and, you know, telling our side of the story and asking the judge about your concerns. One thing we can tell you, as long as there's Senator Grassley, there'll be a question about ethanol. To Senator Feinstein, you're a joy to work with. To our staffs, I know this has been very hard, a lot of pressure on both sides. To the people who set up the room, thank you. To the witnesses who chose to participate today, as private citizens, thank you. To the police officers who made this go well, thank you. To my staff who bore the brunt of this, I really do thank you. So what we're going to do now is end where we began. My view of the Affordable Care Act is different from South Carolina's point of view. We're getting about $1 billion less because of the formula. We're down to 1 exchange. We started with 5 and premiums have gone up. Those issues will be decided at the ballot boxes. Close election everywhere. You know, all I can say is that voting does matter, and I'm sorry that anybody has to wait in line. We need to make sure we deal with that as a nation. But voting participation in South Carolina is very strong. I am happy about that. This is a chance to have your say. The stakes are high, as has been well articulated here. But let me just say, the election will come, winners will be declared, and we get to start over. The thing I like most about democracies is a journey without a destination. When are we going to get there? We never actually do. You know, when you're a child, you're wanting to get to wherever you want, you know, you're excited about going. It really is the journey. And I don't know how this election is going to come out. I'm hopeful for our side. I feel good about it. But having said that, you know, 2016 was a curveball, in many ways, and I just don't know what's going to happen, but the more people vote, the better. And when it's all over, and it'll be over in a few weeks, I'll just say this: if I'm around, I will commit myself to starting over, looking forward, not backward, and to the Judiciary Committee. We've talked about things that really matter. We've had our differences, but we're talking about Section 230. I think that's mattering more every day. And the fact that we had a unanimous vote to make sure that social media outlets earned their 230 protection when it comes to protecting children against sexual exploitation is a darn good place to start. A lot of smart people on this committee, I mean incredibly smart, about antitrust, about intellectual property. So this committee, in my view, even though we've had a rough ride lately, has the potential, if we all embrace it, to engage each other and make America a stronger, safer place. To my friend, Senator Lee, I don't think anybody likes their job more than you do. I've never seen anybody, Senator Coons, you're definitely in that category, who's so enthusiastic about the law and politics. I'll end with this. Judge Barrett, I have had an opportunity to witness several people apply for the job of being a Supreme Court Justice. I've never met a more amazing human being in my life. Not from just the professor who helped the struggling young blind student and everybody else she's helped, but just your knowledge of the law, your disposition, your character, and the ABA rating, I think, was well earned. So the hearing regarding Judge Amy Barrett to become Associate Justice of the Supreme Court is now over. The markup will be October the 22nd. To all who got us here, thank you very much.
We'll do it.
We don't see Mike, the guy with the And finishing up our coverage of the